We want to welcome everyone to Paid Sick Leave, California's new paid sick leave law effective 7/1/15. And it's being presented today by myself, Audrianne Adamsley from HR Network, and Shannon Jenkins from Treadway, Lumsdane, and Doyle. Hi, Shannon.
How's everybody doing today?
Well, we hope everybody's going to be doing better after they learn about paid sick leave. So let's get started.
All right.
Okay, so the Guide to California Healthy Workplaces and Healthy Families Act of 2014, that's where the new paid sick leave law is. We're now the second state in the nation to have paid sick leave to employees, and this falls under AB 1522. And the effective date that you must begin providing this is July 1st, 2015. Okay, so let's go over some of the basics of the law. It applies to all employers. So this isn't for large employers or certain size employers. It's for all private and public employers, regardless of what size you are. And it applies to all employees. Doesn't matter if the employee is full-time, part-time, exempt, non-exempt, on-call, or temporary. In other words, every employee will be eligible to participate in this plan. And for temporary and part-time employees, it's for any person that works 30 days or more within a year, starting with employment that begins July 1st, 2015. They must be paid the 3 sick days per year, accrued at 1 hour of sick leave for every 30 hours worked. This also will include out-of-state employees if they spend enough time in California. In other words, if you have an out-of-state employee who comes and works in California for at least 30 days within the year, they would also be eligible for paid sick leave. Okay, there are a few exemptions from coverage. Employees covered by a union contract that do not specifically provide for paid sick leave, state providers of in-home supportive services, and certain air carriers. So I don't believe we have too many clients or that I'm aware of that may fall under this, but if you think that you might, please feel free to contact Shannon or I, and we'll look into it more specifically. One thing to note, temporary employees of a staffing agency are covered as well under the new law, and whoever is the employer or joint employer is required to provide paid sick leave to qualifying employees. So if you have a staffing agency and they're considered the employer, they'll be required to provide it. But if you're considered joint employers, then you may be required to provide it.
Yeah, let me jump in here for just a second, Audrianne. Can you hear me okay?
Yep, thank you.
Okay. I actually flew to San Francisco yesterday and gave a seminar, did a presentation to a group of professional fiduciaries. And many of the fiduciaries in that group, like many groups that I've spoken to, I gave a presentation to the Board of Realtors in Downey a couple of weeks back. I had no idea that this new sick leave law was going into effect. Once educated on that, and specific to this last point that Audrianne made about temporary employees of a staffing agency, I have encouraged all of the employers that I've spoken to go to those vendors that they might get labor from, whether it be a PEO, a staffing agency, or some other, temporary labor basis, and make sure that those third-party agencies are aware of and compliant with this paid sick leave law, because the issue of joint employer or co-employer liability is very real. It's currently being adjudicated in the courts, and it's really important that you as business owners are proactive in working with your vendors to ensure that they are aware that the sick leave law is in effect and that they're paying properly, because if they're not, then that's going to come back on you as a potential co-employer or joint employer.
Okay, thank you, Shannon. Let's move on and talk about the amount of leave that employees can earn and how it's used. So an eligible employee earns 1 hour of sick leave for every 30 hours worked. whether the hours worked are regular or overtime. So overtime is counted in this as hours worked, beginning July 1st, 2015, or the employee's first day of work, whichever is later in the year. Exempt employees are deemed to work 40 hours regardless if their work week is more or less. They're just set up based on a 40-hour work week. Employees can start using their accrued sick days on the 90th day of employment. So you as an employer can say you'll accrue from day one, but you're not eligible to use it until the 90th day of employment. And that's up to the employer. You can always say that they can use it sooner than that, but that's the maximum amount of time that you can put in it before employees can use it. Although employees earn 1 hour sick for every 30 hours worked, you can limit the number of paid sick days that an employee can use each year to 24 hours or 3 days. And you must allow a carryover of earned sick days which are not used to the following year of employment. I'm going to talk in a minute about an option to that, but it does require a carryover. So it's not a use it or lose it unless you choose to go a different route, which we'll talk about in a minute. The carryover provision allows an employee to have paid sick days at the start of the next year, depending on how many they've already accrued or used. So if they earn 3 days a year and they've only taken one, at the end of the year they'd roll over 2.
Audrianne.
So, yes.
Couple of points here. You may have a situation where you have a part-time employee that only works 4 hours a day. Alternatively, you might have an alternative work week schedule where you've got an employee that works 10 or 12 or more hours per day. So when we say 24 hours or three days per year, you're going to have to understand for each of your employees what kinds of schedules they work and adjust accordingly. For that person that works 4 hours a day, that doesn't mean that you can limit their sick leave to 12 hours, which is equivalent to 3 days. You have to give them minimum of at least 24 hours. Also, if you've got an employee that works a 10-hour schedule, alternative work week schedule, you're required to give them at least 3 days per year. So that doesn't mean that you can limit it to 24 hours. It would be 30 hours. 3 days at 10 hours a day would be 30 hours. So you need to understand that some adjustments may have to be made depending on the hours that are being worked by your workforce.
Great point. Thanks, Shannon. Now, although you have a rollover, you can cap the amount that can be not only rolled over but accrued in their bank each year, up to a max of 48 hours or 6 days. One thing that we are working on right now to try to get clarification from the state on is that the law specifically says that the employer may cap at 48 hours or 6 days. It doesn't say must or can cap at a lower amount. And we're waiting for clarification on that. So for right now, we do know that the cap is at 48 hours or 6 days. Okay, so let's talk about some of these accrual and carryover policies. You can always pay more generously. We know a lot of employers prior to this were giving 5 days of sick leave, for example, and you can continue with your 5 days of sick leave if that was your policy before. The only thing that may have to change is the rollover. A lot of employers didn't roll over their sick leave, so you may have to now implement a rollover provision or any other provision of the paid sick leave law that you didn't have in place before. Now, no hourly accrual or carryover is required if the employer gives employees the full amount of leave beginning of each year pursuant to a compliant policy. In other words, if you front load employees with their 3 days as of January 1, you do not have to provide a rollover in your plan. So in this case, we have an employee who had 2 days left on December 31st. On January 1, they will be provided 3 days of paid sick leave for that next year. They lost the 2 days from last year, and they were front loaded on 1/1 for 3 days for the following year. So that's an option for you to consider if you don't want to do the accrual and don't want to do the carryover. Administratively, it might be a little easier. You are still welcome, though, to do a cap and do a rollover. So, for example, I have a client who has made a decision to roll over up to 3 days and front load 3 days. What that means then is the employee will have a maximum at any time of up to 6 days that they can use in their sick leave account. And you don't have to maintain an accrual, so it's much easier to manage. So there are other things you can do. As we said, you can always be more generous. So your policy must either satisfy the accrual, carryover, and use requirements, provide no less than 24 hours or 3 days of paid sick leave for each employee for each year of employment, a calendar year, or a 12-month basis. So again, you can pick a different date that you want to do your front load. Doesn't necessarily have to be 1/1, but it has to be the same date every year, at which time you would front load 3 days for all eligible employees. Okay, let's continue to talk about accrual and carryover policies. So again, if you want to avoid accrual and carryover requirements, you can front load at the beginning of each year. And you can choose to do a front load on a July 1st, but then if you want to switch to an anniversary or calendar year, you would be required to front load again at that new 12-month period that you've selected. And for employers with unlimited time off policies, which I have to say I don't have anyone that I'm aware of that has unlimited time off policies, but they did put a provision in. The Labor Commissioner's FAQ issued December 2, 2014 states that regardless of such policy, this new law requires employers to separately track sick leave accrual and use and must comply with the postings and notices of the law. And if you're out there and you have an unlimited leave policy, we'd love to hear about it. Okay, so there are different reasons now under the law that we have to allow employees to use their sick leave, and it may be used for diagnosis, care, or treatment of an existing health condition or for preventative care of the employee or employee's family member. And if you look below, you can see that family member is defined. It's more broad than the definition of family member under FMLA or California CFRA program. So family member includes, under the paid sick leave law, biological, adopted, step, foster, or domestic partners, children, parents, spouse, or registered domestic partner, grandparents or grandchildren or siblings. So pretty broad definition of who a family member is. You also have to allow employees to use this paid sick leave if they were a victim of domestic violence, sexual assault, or stalking. So we have a law and a policy already in the handbook that talks about crime victim, and it was an unpaid leave. Now, employees who may be a victim of a crime, if it's domestic violence, sexual assault, or stalking, actually can get paid by using their paid sick leave. And the Act also states that employers may not require employees to search for or find a replacement worker to cover these paid sick days. So, for example, you're a restaurant and you have a policy that if you want to take the day off, that's fine, but you have to get your shift covered. Well, if somebody's out sick, under paid sick leave, you can't require them to have to get their shift covered. Okay, let's talk about permitted use of sick leave. So notice of sick leave request from the employee. Paid sick leave must be provided upon the employee's oral or written request. If the need for sick leave is foreseeable, the employee must provide reasonable advance notice. If the reason for sick leave is not foreseeable, the employee must provide notice as soon as is practicable. So it's unclear whether this applies to all your current call-in policies. So if you have a call-in policy, and for clients, we generally put what the call-in policy is. You must call in at least 30 minutes prior, 60 minutes prior, 2 hours prior. That you cannot, and in that current policy, it says that if you don't call in properly, we can call this an unauthorized leave or withhold you using your sick leave or PTO or whatever. You can't do this under the paid sick leave policy. As long as they make an oral or written request as soon as they possibly can, even if it was 5 minutes before the shift started, you would and they had paid sick leave available, you would have to give them their paid sick leave for that day. Okay, increments. You can set whatever reasonable minimum increment, but it cannot exceed 2 hours. And the employee can determine how much paid sick leave he or she needs to use. So meaning not to exceed 2 hours means that if I leave early, for example, and you have set the increments of paid sick leave at 2 hours, leaving early for every 2 hour increment, I'm going to get paid 2 hours from my paid sick leave bank. Now, you can do less than 2 hours. You can set a 1 hour increment. You can even set, a 15-minute increment if you want. I don't really suggest that because administratively it's very difficult. I think probably the easiest increment to administer is the 1 hour increment. Okay, this is an interesting twist of the law, and we are working right now to get further clarification. But right now, how it's written is paid sick leave must be compensated at the employee's hourly wage and must be paid no later than the next payday after the sick leave was taken. There's a big note, though, here. If an employee is paid at different hourly rates or by commission or piece rate, then you have to do a look back of their average wage, combining all those different rates of pay to come up with an average hourly rate in which you will pay the sick leave. So this is very concerning. I know we have some clients already quite concerned about the idea of, gosh, if I add in commissions paid and their regular hourly rate or wage, and then over the last 90 days, and then do an average based on hours worked, that hourly rate's could be 3, 4, 5 times what the regular hourly rate is, and I'd have to pay them the paid sick leave based on that average rate. Right now, that is correct. That is how we understand it. Although, as I mentioned, we are looking for clarification from the state on this particular issue.
Yeah, and if I could just jump in here on this one, like I mentioned, I co-presented at the Professional Fiduciaries Conference in San Francisco. I did it with 2 other employment defense lawyers who handle everything from individual claims to class action, so clearly well-versed in the law. And we had a conversation about how you calculate the rate to be used. It is still an issue. And we also came to the conclusion that you take the most conservative course, which is utilize the regular rate, just as Audrianne defined it. But the fact of the matter is, this law is so new, only being on the books since January 1st, not even yet implemented until July, that we're going to have to wait and see how some of these issues play out in the jurisprudence and the agency decisions that come down the pike. We, as HR advisors and counselors, will tell you to take the most conservative course, even if it is the more expensive course, unless and until there is some definitive guidance about with answers to some of these questions, like what rate do you use?
Okay. Okay, let's continue talking about compensation. So lending paid sick leave to an employee. An employer may lend, that is, advance prior to the accrual, paid sick days to an employee in advance of the employee's accrual of the sick leave at the employer's discretion and with proper documentation. And right now the Act doesn't specify what kind of documentation is required. So this is an option to employers, and if it's something that you are willing to allow someone to do, if you are on accrual basis, then that should be written into your policy or your handbook. There is no requirement to pay this accrued sick leave out upon termination. Unlike accrued vacation or PTO, where you are required to pay it out, you do not have to pay this out upon termination. Now, if your sick leave falls within a PTO policy, however, you would have to pay it out because PTO is treated as vacation in California. One thing we are also still trying to get clarification on is if you add days to your PTO policy to account for the paid sick leave, or even if you don't add days, but your PTO policy matches what is required, or has at least 3 days available for an employee to use for sick leave, you don't have to change your PTO policy. But what we don't have clarification on right now is those 3 days that you carve out to be allowed for sick leave under your PTO plan, do they have to be paid at the average rate? And again, as Shannon pointed out, we feel like you should do that and take the most conservative approach until clarification is made. Okay, one other point about this law: if an employee separates his or her employment, in other words, they, for any reason, but is rehired by the employer within a year of the date of separation, any previously accrued and unused paid sick days must be reinstated, and the employee must be allowed to use those previously accrued sick days and begin accruing again immediately upon hire. So if somebody were to leave in July, for example, and they had 2 paid sick days left, they wouldn't get it paid out. But let's say you rehired them the following February, you would have to give them back those 2 days that they had left in their accrual bank and then start them back on accrual immediately upon hire. So this is going to require some record keeping, but we're getting to that. Okay, there's 2 important notices to employees that should have been given out already. And don't panic if you didn't, but hopefully you'll learn today and be able to get this out to your employees. The first is to provide a notice with the paycheck. And the notice is called Notice 2810.5. It is a labor code. It's part of the labor code section. And you were to send it out to employees earlier in the year as a 1/1 to let them know paid sick leave is going to be made available to them. Now,
well, this was for the non-exempts, so that should already have been in place. But you probably weren't providing this for your exempt employees,
right? So this is the labor code notice that for non-exempt employees, as Shannon said, that you provide upon hire and upon change of any information on the form. So the new form has a paid sick leave section on it. If you aren't using the new labor code section 2810.5 notice, then you need to download that. You can get it from the DLSE website, and you need to start using it. You should also, now that you're probably updating your handbook for 2015 and putting your new paid sick leave policy in the handbook, employees won't wonder what that is because you're going to be notifying them anyway of this program. Okay, there's also a poster that should have been posted as of 1/1/2015, and it's a poster specifically about the paid sick leave under California law. If you ordered an all-in-one poster, it should have been on your 2015 all-in-one poster. For clients that we provided posters for, it was on there, so no concerns. It is also something you can go to the DLSE website and download. And if you are not a client and calling in today but need a poster, you're welcome to contact us via email, and we can help get you set up with posters. Okay.
Yeah, and Audrianne, let me jump in here real quick. For those of you who have employees that work remotely, either from home or they work in the field or in remote offices, that doesn't relieve you, obviously, of that posting requirement. Many people employ caregivers that work in residential homes. For those remote employees, you should provide a packet of information. You won't necessarily have a break room where you will hang a posting, but every employee should receive their postings and their notices in a packet or someplace that is readily accessible to them if they're remote.
There's another alternative too, for employers that may have remote employees. Is you can if we have available an e-poster, and you can put it on your server. You just need to make sure that those remote employees have access to that information, have been given notice of where the information is. But it's something that might be an option as well. Okay, record keeping under the new paid sick leave law. Employers need to maintain records for at least 3 years documenting the hours worked and paid sick leave accrued and used by the employees. And these records need to be available to the employee the same as any other payroll report or payroll record, that is within 21 days of the employee's request. Failure to keep adequate records could, of course, get you a fine. And so it is part of your payroll report, so it's maintained just like you would any payroll information. Okay, penalties for noncompliance. You cannot deny an employee the right to their paid sick leave. You can't discharge, demote, or suspend them in any way or discriminate against them in any way for using their paid sick leave. And if you retaliate in some way against an employee, the employee can file a claim with the labor commissioner alleging the violation. They can, and of course, you might have a labor claim as well. Also, if you don't post your poster, it's $100 for each offense. And the award that can be provided could be reinstatement, back pay, payment of sick days, unlawfully withheld interest, administrative penalties. In addition to that, the amount can be multiplied by 3, triple damages, or up to $250, whichever is greater, not to exceed $4,000. In other words, like any wage claim, this could end up costing you a great deal of money if you're non-compliant.
I have a concern because I've seen it more than once in a litigation context, and if I'm seeing it at that point, then it's already too late. But for those of you that use out-of-state payroll companies and large payroll companies, they oftentimes will not cue in on laws that are particular to California. And when you think about things like the minimum wage, laws that are specific to counties and cities, it's truly incumbent upon you to audit your payroll records and payroll service provider to make sure that the record keeping is accurate and it's adequate. Because when you talk about these penalties and the potential exposure for noncompliance, it can get, especially for a small organization with a number of payroll periods at issue, can get very expensive.
That's a great point, Shannon, and I want to add on to that. So I have a lot of payroll companies, or I have a lot of clients where we've talked about that issue, and they assume that their payroll company is making sure they're compliant. One thing to know, there's even a law protecting payroll companies. They are not responsible to ensure you are compliant. It is your responsibility. And one thing, we didn't put a slide up on this, but I want to point out, this law requires that you actually show on the pay stub the amount of accrued sick leave available to that employee and the amount used when it's been used. So you'll now have to have a separate line item or box on the pay stub that requires, it's called accrued sick leave. And if you use a PTO program instead, then you're going to have to show it under the PTO program. But you are going to have to show the employee the amount of accrued leave they have available. And then if they use it, another box to show accrued sick leave used. Payroll companies are gearing up for this. They are preparing for it, at least the smaller ones in California. But I can't say that, just like Shannon said, for some of these large national companies or out-of-state companies who don't typically, aren't typically compliant for California rules. So that is something for you to check into. Okay, we are going to open it up for Q&A. And I'm going to unmute everyone. I'm going to ask you that if you don't have a, do have a question. Actually, let's take the question first. If we have a PTO policy, can this qualify as sick leave, or do I need to change the classification from vacation and PTO? This caller has quite a few questions. I'm going to start with that one. If you have a PTO policy, you do not have to change now to a vacation and sick leave policy. As long as your PTO policy meets the requirements, the accrual requirements, the cap requirements, the use requirements of when can be used. So as long as your PTO policy has at least 3 days available that can be used for the same reasons as paid sick leave, and it meets all the same requirements, you don't have to make any changes at all. I am
cautionary note though, if you only offer PTO to full-time employees and not any of the other classifications that have access to the sick leave, then the PTO policy itself will not be fully compliant. So you've got to make sure that there is some eligibility for the balance of the employees and not just the full-time. The other thing is if you have a PTO policy that is not compliant for whatever reason and you want to maintain your PTO policy, you're going to need to, on the pay stub, reflect both the PTO accruals and then separately the vacation accruals, so that those items can be tracked.
Also, I want to point out, a good point, Shannon. We've had quite a few clients who wanted to keep their PTO intact for full-time employees. So in the handbook, we've added the paid sick leave for 3 days for part-time and temporary employees. So you can do that. The other thing is, do you need to add days to your PTO because of the paid sick leave? And the answer is no, as long as you have 3 days available. However, something to think about is employees know this is coming. So be prepared to get questions to ask, why aren't I getting 3 more days of leave because of this paid sick leave? I suggest that if you have a compliant PTO program, you still might want to add a day or 2 at least to kind of compensate for the paid sick leave program. And the way you communicate that to employees is if you're not usually out sick, you've just earned another 1 or 2 days of vacation. Okay, next question. Can we pay in lieu of giving days? And I don't believe you can do that in this program. There's no provision for that. Next question. I don't understand the front load. Are you saying we must give 3 days before they have accrued 3 days? So sick leave paid at regular, even though some hours were accrued via overtime. The 2 options again are either an accrual basis or a front load basis. So if you front load, as of July 1st, everybody's going to have 3 days sitting on the books. You don't have to worry about what rate of pay it is until you actually pay it. Once they use it, they've called out sick and they say, I'm ready to use my sick leave. You have to pay it at their current hourly rate or average hourly rate, including any other commissions, piece rate, etc. If you accrue it, then it just gets accrued hour by hour. For every 30 hours that they worked, they get an hour accrued into their sick leave account. Okay, so sick leave paid at regular, even though, okay, we answered that. All right. If your anniversary date is July to July and a new employee starts in December, how do you track this? Well, on an accrual basis, they would just start accruing from day 1. If you were front loading, you would front load 3 days. Another question that we have proposed or asked the state to get clarification on is if you can prorate it based on when they worked in what part of the year. But as of right now, it does say that if you front load, you must front load 3 days, and that those 3 days would be available for that 12-month period or up to the date of which you start front loading again. Okay, next question. Oh, I'm glad somebody asked this too, because this is an issue. Can you require a doctor's note or proof the employee was out? And what if they are out sick 3 days in a row without proof? I'm glad you asked that, because normally we do ask for a doctor's note if an employee's been out 3 days or more. Under this law, you cannot require a doctor's note. That's concerning, but it is part of the law. You can't, and if they don't provide a doctor's note, you cannot say they can't have their sick leave. You must provide it even if they don't provide a doctor's note. Now, you can have a policy, though, that says you require a release. If somebody's been out sick for 3 days or more than 3 days, you can require a doctor's note. If somebody has been out with something that you're concerned about the safety of others or themselves, or risk of hurting themselves or injuring themselves at work, you can also require that somebody come back with a release from the doctor that they are okay to work. And there are policies you can have about, you can still have workplace policies about calling in, about typical rules of conduct. You just cannot deny somebody their paid sick leave because they didn't provide a doctor's note.
Well, and keep in mind that the sick leave law would be available for non-sick related activities, such as the victims of domestic violence, assault, so on and so forth. So it makes sense that for that 3-day period of time that a doctor's note would not be required, and in fact you cannot require it.
Okay, so I've got 2 people kind of asking the same thing. Is 3 days the maximum in spite of hours worked? And if we front load as of 1/1/15, do we need to add an additional 3 days? Our policy is more generous than 3 days. The law simply says that as of 7/1, you must make available 3 days per year of paid sick leave to employees. So if you're already providing at least 3 days of paid sick leave to employees in 2015, or your policy is more generous and you provide 5 days, or you've already front-loaded days, then you don't have to worry about how many days you offer. You can always be more generous. You just have to make sure that the accrual and cap and use requirements are in place as well. Okay. We have a sick PTO policy that allows employees to roll over unused sick hours at the end of the year to vacation PTO, or we pay out remaining sick hours. Can we still do this? I don't see why not. Sounds more generous than the law. I don't see any problem with that. So as long as you meet the minimum requirements of the law, again, you can always be more generous. Okay, I'm not seeing any more questions come in. We'll give it a minute more. Any closing thoughts you want to say, Shannon?
No, I just wanted to say that either Audrianne or myself are available to assist you with any questions that you have. My suspicion is that once the Labor Commissioner responds to Audrianne's request for an opinion on some of these outstanding paid sick leave issues, that we will probably update this seminar. And if you have any questions in the meantime, shoot them off to either of us and we'll be more than happy to help.
Okay, 2 more questions came in. I'm going to take those and then we'll wrap it up. So can an employee tell you any reason they are using sick pay and you can't require proof? And I understand that question. I've had lots of employers ask it, and the answer is correct. At this point, because again, there are many reasons why they can use it. It's essentially 3 paid days now in place for employees for the reasons that we listed earlier, and you can't require proof of that. Another question, is there a spreadsheet that will help me with logging? HR Network is actually working on a spreadsheet right now, and it should be ready to go prior to sometime early June. So if you are a client of ours, we will definitely have that up on our employer pack, and we will let our clients know when that's ready. And Shannon will share that with you so you can send it to your clients as well. And then lastly, can your presentation be downloaded? We will, for all attendees today, you will be sent the presentation via email. And again, when you get the email with the presentation, if you have any final questions, please feel free to reply back, and Shannon and I will get back to you. So thank you, everybody. We're glad that you joined us today. I hope you'll join us next month when we're going to talk about wage and hour issues, and an announcement or an email on the specifics of that will be going out shortly. Thank you for joining.